right, thank you for staying with Daybreak. We're still having that conversation on the judiciary in crisis. Who is to blame at what point? What is the weakest link? And that's the conversation we're having at @Tribumbijitizinzi_K and at Citizen TV Kenya, #Daybreak. You wanted to bring up a conversation, Kinyua.
Sure. I want to agree with Steve Ogolla that it is true. We have no shortage of good policies, shortage of good law. We don't have. But the handlers of these matters, the institutions, have a problem. That's what we are saying. They have a problem. And what do we do about them? And I give you an example. Recently, I was called by a lady who was put in a Rangata prison for the first case. He had two cases. The first one was a criminal assault. The other one was criminal damage. The first one that was taken to Langata, the accuser is actually his complainant in another case, High Court, where the lady has accused this man of grabbing his rat. Now this man goes and frames a criminal case against this lady. This lady is taken, denied bail, and taken to Langata. After 2 weeks, this lady comes out. He comes out, he finds that this man has already sold the rad, the piece of rad. And there is already a favorable decision in favor of this lady. This decision cannot be produced before the magistrate court, who is handling the criminal matter, to show the connection between that case, because this decision is being sat on by another judicial officer in the High Court. You see, that was the challenge, that she cannot prove she has a favorable decision over this civil matter, and that's the reason this guy is framing a criminal case against her. So again, he connives with the new buyer of his land and takes the lady back to prison on a case of a criminal damage, on a plot that he has already a favorable decision on. So I went there to help the lady to get this judgment, this favorable ruling. So I took her to the High Court. Again, they refused. They said this lady has to come with a letter from the lawyer. Then I said, if she could not manage to hire a lawyer in the first place, how do you expect her to get a lawyer to write a letter for him? It is her right as a party to the case to get a copy of the ruling. So they told me, no, that's how we do it here, unless you go to the registrar. Yeah. So I took the letter to the registrar, and the registrar ordered that the ruling be released. And that's how she secured. That's what I'm saying. Yeah. The magistrate could not lift the curtain and see the reasons why these criminal charges are framed by this person. The fact that this person, is a defendant in a case accused by this, but in the High Court. Yeah. You see, these are the cases we are saying. Who fails? Because the magistrate, if she has this information, could be able to see the reasons behind.
That's not true.
Okay.
No, this is true.
No, not the facts. The procedure is, and I say that because you're not a litigation lawyer, so I say this with clarity. What I hear him saying is this: Kenyans don't understand the intricacies of the criminal trial. First of all, there's what we call jurisdiction. Jurisdiction. You can't handle a matter which you're not permitted to handle as a court. Number two, there's the case before you. There's no room for chaotic expansion of the case before you, because the judge or the judge does not frame the charges. There could be so many things happening around the case, or there could be so many other intrigues that are going on outside the case in other courts, but this court is not aware. If there is there's reason to believe that this matter is properly before the court, and the court is misapplying itself or refusing to exercise its mandate, then there are procedures for appeal, for revision, to the Judicial Service Commission for complaint. You get? What Kenyans need to know is this: if you are charged in court, because we're talking about criminal trial or criminal justice system in the context of the justice system in the context of prosecutions. Yeah. The first thing to know, the charge sheet. How are you defending the charges that are framed in court? Don't come to court with another case which is not in court. Because the mind of the court looks at the charges presented. That's the first thing. And I've said before that even the courts have some residual obligation, let me put it that way, to look at the charge sheet for integrity, for stability, and also just to preserve the integrity of the trial process, you can look at the charge and say, no, I find a problem with the charge and raise it, number one. Then during the conduct of the case, because you are arrested, you are arraigned, you take plea of not guilty. Then you do case management. Case management is where we do discoveries. You are given all the materials that the prosecution intends to rely on during your case. You are given in advance. The court is supposed to ask, before you take a trial date, do you have all the materials, all the evidence that the prosecution has against you or not? That's not interfering. That's not being partisan. It's just a normal, you're trying to preserve the integrity of the process. As a magistrate, I shouldn't allow trial to commence without being sure that this accused person who is unrepresented does not have the documents. If he has a lawyer, I don't need to intervene because that's why he is a lawyer. Do you have all the materials? Have you been given an inventory, a list of the documents, witness statements, documentary evidence, exhibits that they want to rely on in your prosecution? Yes. I have already helped as a court without being seen as biased. During the prosecution, if the prosecution is tendering evidence in a manner that is highly objectionable, if you had a lawyer, the lawyer would raise an issue. As a court, I have some residual obligation to say, no, counsel, I don't think you want to proceed that way in the interest of justice. So there are some interventions, small ways that you can make in court.
So how does a Mama Mboga handle all this? This is where my concern is. So how does a Mama Mboga know all these things? Because the question is, should there be a synchrony of these issues? Mama Mboga simply knows this is my land, this person is now accusing me that I've assaulted him, and I have status quo that as the passing by a different court to say this land should remain. I come out of court, I come out of prison, my land is sold. How does a Mama Mboga handle all these things?
Actually, this is now, I consider this civic education. So Mama Mboga is watching, and those who are watching on behalf of Mama Mboga, now they know that if a case in court, there may be processes that you need to be aware of, but you're not aware of. So one way of dealing with those processes is asking, is there a community paralegal where I stay? Can I walk to the courtroom and ask for assistance that, what do I need to know now that I have a case and I've never been in court before? Is there anything that I need to know in preparation for this case? Then come and tell us, I went there and asked that question and I was turned away. Go visit LSK offices. Yeah. I have a case here. It's a criminal case, then there's another case around this case. What do I need to know? If LSK turns you away, which is unlikely, go to the civil society. So,
Steve, all that sounds very beautiful and very glossy.
We have settled
imagine a 19-year-old girl from
Can I say something?
Let
me say something.
No, just listen. Let me just now don't devalue the input I'm making. What I'm saying is very important, and it's to the benefit of the. What I'm saying is this: there are many Kenyans who don't understand how the justice system works, be it criminal justice system or the civil justice system. The civil justice system, where you deal with everything else that is not criminal. Many Kenyans, and I'm saying the first step to addressing that gap is pointing to opportunities where they can get information. I've already solved that. I've said if you have a matter in court and you've never been in court and you have no money to hire a lawyer, at least it works well to know that if you keep looking, you can get a lawyer. That's a fact. I'm not just making a populist statement. Number two, even if you don't get a lawyer, you can get information that can help you handle your case in what we call self-representation. Now, I want you to rephrase your question, Zizi, so that we get out of those 2 points that the public now know in the context of Mama Mboga. If Mama Mboga's land has been stolen and sold while she was in prison, when she comes out and the moment she has that and then she has gone to court, the way he's saying, and he has a judgment, you don't give up. If you can't find justice in the court system, you go to LSK, you keep talking, you will get...
Steve, you'll be 90 and you'd have kicked the bucket. That's the thing. That's the unfortunate thing. It sounds so easy.
Yes, that is what I'm trying to say. Yes. What is justice? That we must ask ourselves that question. And the problem I have with those people who apply justice, including the lawyers and the judges, is that system of mechanical application of the law. I do not agree that. I believe law... justice is something above, merely parroting the law as it is and applying that way. That mechanical process. It's about even try. It's going beyond that. Lifting the curtain, knowing what surrounds the case. That is what I'm trying to say. Mechanical application of the law has led people to, very wrong decisions, especially when we have unfair laws, and we have unfair laws, but you give fidelity to the law, and you end up giving the wrong decision. My point is this. In this case, where I wanted you to respond, is that it's not about handling the case in different jurisdictions. It's about the fact that the judge has given an opportunity to this lady to respond to the charges. Why is this happening? And the lady has said, this man is grabbing my land. I already have a favorable decision, and that's why he's framing my case, this criminal case against me. And the magistrate has given her an opportunity, to prove that. Getting that favorable ruling from the judiciary to go and from the High Court to go and deliver it to the magistrate.
That is where the problem.
That is the problem.
Even if I wanted to help him, I don't have the facts.
Is it because of?
So he's litigating a matter.
So not litigating.
No, hold on.
I'm giving an example.
In the court of public opinion, Trevor, I don't have the benefit of the facts.
That is true.
To review, but let me say this. I think there's a point Kenyans are not getting. I think he's not getting it, and maybe Kenyans are not getting it. Nobody feels aggrieved without any reason. So I think that covers his case. By the time you feel aggrieved that something is not right, if you feel something is not right here, ask, where is the opportunity to have this decision reviewed?
Steve, is there corruption in the
justice system? That is where the problem is.
Now,
is there corruption in the judicial system from where you stand?
I'm going to answer that, but let me just complete this statement. If you feel there's something wrong here, within the justice, we have provisions for revision. Revision means you go back to the same court to have a look. You go back to the higher court to have a look at the lower court's judgment. There's appeal. You go to higher court to have that lower judgment reversed. You have a constitutional petition. You can say, out of this case, something has arisen that requires to be defined as a right, a pronouncement as a right. So the bottom line is this, Trevor. In all cases where Kenyans feel aggrieved with the criminal justice system, when you feel aggrieved, we don't devalue your grievance. We say nobody feels aggrieved unless there's reason to. When you feel aggrieved, the next step is, how can I find another neutral place to have my grievance addressed? They are there. You asked about corruption.
Steve, we're not disputing that.
Let me answer.
Let's now do it hypothetically speaking.
You've asked about corruption.
Yes, the judgment is there. Mm-hmm. You just want that judgment to be proven, to be given to you, and you simply can't get it. But you have it. Is there corruption in the judicial system? That's the only thing.
I have a master's in governance. So I can tell you, when you talk about corruption, our country is steeped in corruption, it permeates all sectors.
Of course, including judiciary.
Including judiciary.
How deep
it is not safe. I don't have
You're
the indicators
lawyer,
to measure. I don't have the statistics. I personally, I can't sit in my chambers and say corruption is this deep in the judiciary. But here's the thing. There's reason why people say there's corruption in the judiciary. And I don't think it is safe for a lawyer or a judicial officer to devalue that concern. Mm-hmm. When people say that the judiciary is steeped in corruption, it's because they have experiences. The way to address that, and although it's always been an ongoing process, but let me give Kenyans, case by case, you contextualize your issue within this framework, because there's a framework for addressing everything. Mm. If you feel that a judge or a magistrate has not handled your case well, you refer the matter to the Judicial Service Commission. Even the DPP himself. Mm-hmm. This issue of bail term of Honorable Babu Owino, the DPP complained to the employer of that magistrate. There's a complaint against the magistrate for misconduct to the employer. The DPP knows that if the magistrate misapplies himself, I can complain. Kenyans should know, if you feel that the way the court is handling your case raises questions, you can complain the employer of that judge, the Judicial Service Commission. Number two, if you feel aggrieved within the system that there could be corruption, my file has gotten lost, I can get a judgment, you write the executive officer of that court. Mm-hmm. If the executive officer is not responding, you take it to the Law Society of Kenya. Now I'm doing public sensitization. It is not possible, Zizi, I would really be surprised that you have a grievance, you have written the Judicial Service Commission, you've written the executive officer, to get the file, you've gone to LSK, you've gone to civil society organization, and there's no support.
I hear you, Steve.
It's not possible.
What do you make of
it is possible. It is possible because
those are the
I'll give you
solutions.
an example again. Let me give you another example. Away from the judiciary, let me now go to the LSK members. Yeah? And another case where somebody has hired a lawyer, and a lawyer has taken the money and has not represented this person. And when he demands the money, this money is not forthcoming. He complains to the court. You know, the court tells him no, refers that person to the LSK. That is the procedure, right? You go to the
because
LSK.
you're complaining the wrong forum.
Yeah.
If you have a problem with your lawyer,
Yeah.
and this, Kenyans are not just aware. You have the Advocates Complaints Commission, a publicly funded body.
That is where I was
Hold
going.
on.
That's where I was going.
A publicly funded body
Yes.
to deal with. Then you have the Advocates Disciplinary Tribunal. Even right now, during these campaigns, we're going to elect our representatives, the tribunal, that deal with issues like this. You have a complaint against a lawyer, take it to the Advocates Complaints Commission so that it can be addressed.
Yes, that is where I was going.
Now, if the Advocates Complaints Commission has not addressed it, and the LSK, the Disciplinary Tribunal has not addressed it, you can go back to court file a separate case.
Okay.
Okay, we need to touch on integrity of
Yes.
lawyers. We're coming to that in just a little bit. But Wilson, I have a question specifically for you. 21 years in prison, arrested at 19 years. Youthful years behind a cell. Did state ever compensate you, and what did your compensation look like? Were you satisfied with it?
No, I was not given any compensation. First of all, I went for this case that that nullified mandatory death penalty. So I did not resubmit my case to clear my name. So what I did was to challenge mandatory death penalty for the benefit of so many people, 8,000 inmates who benefited from that case.
Yeah.
You know, so that case does not, absolve you from the blame. You know, I had already gone above, the priority of clearing my name and thinking about the bigger problem that we have, having very many people with criminal charge, capital offenses with trivial content of responsibility, and those were the issue.
Okay.
People inside prison sentenced to death for robbery of chips and sausages.
And our,
Those are the kind of
our
thing.
viewers may not know this. The same way you represented yourself, you represented your fellow inmates.
Yes.
Did those inmates also get compensation?
They did not. I'm saying you can only get compensation if you are cleared.
So
You know,
even
we
those
did not
individual-
go for clearance.
Even
What
for
do
those
you mean
individuals-
compensation? Just so that I can contextualize. I hope you're talking about the Francis Muratetu case. Why in that case? Because
Muratetu case?
that is the only case. Let me tell you, I can inform you, because these shows are watched by the public, the lawyers, the judiciary watch these cases.
Yes.
And I'm duty bound, because I practice in these cases. There are some gaps. And there's a problem with the question of frame, so I need to clarify so I can answer. The only guideline judgment, there could be many. The only guideline judgment that was issued in 2015, 2016 by the Supreme Court, the Francis Muratetu case, that abolished the mandatory death penalty. It said mandatory death penalty is unconstitutional, but the death penalty in and of itself is not unconstitutional, which means death penalty was retained as a maximum sentence, right? Mm-hmm. So, because of the mandatory nature of that offense was removed, it means the trickle effect or the ripple effect is that any offense that has a mandatory sentence must now be read to be a maximum sentence. Mandatory is now maximum. You get? So what is the question about compensation? Because compensation in the criminal justice system is different.
Mm-hmm.
No, before you answer there,
Steve
please,
wants all of us
let
to
me
be
let me
lawyers.
also
But we're
inform
talking
you.
about
It's
Mama
something
Mama
I want to
here.
inform.
What is the-
That's
no,
that's
allow
my
me-
frustration.
yes,
as a
allow me to
lawyer.
inform him something.
Clarify the
Yeah,
question.
allow me to
Hold on,
inform him
he'll come.
something.
No,
Yeah.
just,
We are coming back to you.
just clarify the question about compensation. Because what is in my mind as a
Wrongful
lawyer-
incarceration, maybe.
let me tell you, there will never be such kind of compensation. I can tell you, I'm telling you with clarity of mind. The only way to get compensation for false prosecution is if you file a case and the court determines that, listen, in this particular instance, you ought not to have been charged. And those are very rare. Because you see, there's the presumption of legality, the presumption that the prosecution, the DPP, acts in good faith. He doesn't need to get a conviction in your case. All he needs to do is to have a belief
That he should have been
that
charged.
his reading of the law that an offense is disclosed.
Okay.
Whether that offense is elevated the threshold of a conviction, that is for the criminal defense, the prosecution, and the court
Does
decide.
Kenya have a proper...
You don't get compensation because you're prosecution. You've been subject to prosecution.
Incarceration,
You get
even if you serve
prosecution
21 years, nothing.
if you were
If you
unlawfully
later on-
arrested,
Yeah.
illegally detained. Now, those are now particular instances. Give me an instance, then I can tell you in this case, the law says you must be arraigned in court within 24 hours. If you are arrested, detained for more than 24 hours, there's need for a rational, logical explanation. Okay. Why?
Steve, when you say
barring
lawyer,
that, then you can be compensated.
Steve, when you say as a lawyer that those individuals, those victims will never get any compensation, does that also mean that you have no confidence in our compensation system, if we even have one?
You know, broadly, if you talk about those, maybe I can. There's a better word, reparation. Reparation talks about compensating people who are the state. You know, the state is supposed to protect you. Then it has failed to protect you, and you've lost your loved one, they've been killed. That is different. And we're not discussing reparation here. If you're talking about compensation arising from a criminal case, the only way you can get compensation arising from a criminal case, and I'm saying this with finality, because that's the law, is if you show the court that you are wrongfully arrested in the circumstances, and that your trial was a waste of time, and was an abuse of the court process, then you can be compensated. Okay. But ordinarily, people don't get compensated because they were acquitted from a criminal case.
We can't close this show without talking about reforms. Kinyua, we want now to talk about reforms.
Before, there's something that we must inform.
Very briefly.
What Ogolla has said. Yeah. Even my law class also taught me, Ogolla, that if a ruling is made by the High Court, and then a court of higher jurisdiction uphold that decision, that law has been generated by the High Court, right? So the first declaration of nullification of mandatory death penalty is not in the case of Murwatetu. It was done in the case of Joseph Kaberia Kainga and 11 others, a constitutional bench of 3 judges, and therefore the case of Murwatetu only upheld a decision that had already been made generated by the High Court.
So let's talk about let's not go to that on that. Let's talk about the reforms in the judicial system. What would you like to see henceforth? If they're listening now, just give me 2 or 3.
First of all, judiciary must deal with those small-time briberies in their back rooms, in the registries and all that. Yeah. Because those are the causes of the derailment of cases, disappearance of evidences, disappearance of files, pieces and all that, delayment to produce a proceeding so that appeal can be had, all those ones. As we speak, there are people in prison today who have stayed for 17, 15 years waiting for their appeal. Okay. I can mention the names here, but I can't do that. So I have the names, but I can't mention them here. People who are already in prison waiting for their appeals. Okay. They are there because of that kind of disappearance of file, disappearance of evidence, derailment to produce all those ones. All right? Number 2 is about dealing with cases of miscarriage of justice. Even after exhausting the trial proceedings, there are legitimate claims of miscarriage of justice. But in Kenya, we have no problem of revisiting these questions. In the UK, we have a system we call Criminal Justice Review Commission. They have a system of subjecting such matters, claims that are worth of belief, subjecting to further scrutiny, and then recommendation to either the High Court to review those cases. In Kenya, we doesn't have this system. We learned to the Article 50 that allows that you can reopen a matter in court. But as somebody who is in custody does not have the luxury or the opportunity to be able to investigate his own case and present the evidence, because Article 50 requires you to present that evidence. But you see, we need a system that can subject that process to her. So there are people who are complaining of miscarriage of justice, they are still innocent, but we have no mechanism of, subjecting those cases
All right, Kinyua. So review. 2 things, small briberies, miscarriage of justice, reforms.
Trevor.
Yes, very briefly.
The first key reform targets the public. Information flow. Let us broaden information flow, because information is power. Without information, you make decisions based on rumors and guesswork. What can we do? All the 8 role players, what can we do to be sure that the public is properly sensitized when there's still time, not when they have a case in court, so that they know what to do?
So there's sensitization.
Sensitization is very necessary.
Yes. Second.
Number 2, there are those back-end corruption. That is not courtroom corruption. Back-end corruption, I'm talking about now civil cases generally, where your file has disappeared, you can't get a date, but someone you can pay a clerk to push to take the file, to give it a date, and so on and so forth. That one, if you pay a bribe, you are deepening the problem. So you don't need to pay a bribe, but you can report. We have the Judiciary Ombudsman. You have the public needs to know you have the judicial ombudsman that receives complaints against judiciary officers, staff. And you have the ODPP, you have the LSK. You can even report the nearest police station.
Okay.
That to deal with back end corruption.
Got it. We
Formal
really
corruption in the
time.
court.
Yeah.
I'm going to just finish in 30
Yes.
seconds. Formal corruption in the court. You have the Judicial Service Commission, the employer,
Okay. and
and you have the LSK, and you can even write the Chief Justice directly with the head of Judiciary.
Okay.
When you take these interventions in the context, we will have a better, effective judiciary. But let us not neglect the formal procedures for appeal, for revision, for filing constitutional petitions.
Okay.
I think that's what we need to do.
Steve Ogolla, advocate, thank you so much for making time. Wilson Kinyua, lawyer and former inmate as well, and now running an institution, Criminal Justice Dialogue. Thank you so much for making time this morning. Do we have time to read the feedback, or do we have to take a break? Let's take that quick break now. Daybreak will be back with much more in just a bit.